Hi, I'm Debbie Moraes, and once again, welcome to Legal Matters, the program that's been designed to address critical issues facing consumers and businesses today. It's legal information, practical solutions, and straight talk about a wide variety of topics that will affect your home and work life. According to a Wikipedia entry, if you think you've been injured physically or psychologically as a result of negligence or wrongdoing of another person, company, government, agency, or other entities, this is the essence of a personal injury case. That's our topic for today. There's certainly a lengthy list of causes: injury at work, stairways where people fall, stress at the home, at the grocery store, at the hospitals. We also know that many people will contact maybe a lawyer instead of just the police or an insurance company. Who should actually contact a lawyer, and when should they do it? There's a lot to be said about what you should watch out for, and what exactly does a lawyer do? We have one who handles such cases. They certainly do earn a lot of money, legitimately, sometimes not so. So let's get the facts. Let's welcome, not Jackie today, she's not with us, but David Bazar from the new partnership, Bazar and Grasso, law firm in East Providence. David, welcome. Set us straight. Tell us.
Well, where do you want to start?
Well, I know it's known as tort law, and it's casts a wide net, but what you do is considered to be also ethical and professional. Not too many people know about it. We just know about the bad rap. Right. Why don't you set the stage for that, David?
Sure. Well, as you call it, tort law, personal injury is all a form of negligence. And so to recover for someone else's negligence in Rhode Island, you have to have somebody who's breached a duty to you. So they owe you a duty, they breached the duty. As a result of the breach of that duty, there's an injury, there's a causal relationship between your injury and what they did, and then the damages are what we assess and we recover for you. So those are all the legal terms that go into it. The long and short of it is somebody's done you wrong and they caused you injury, and it's as a result of what they did, you're entitled to recovery.
And recovery, does it just and only mean financial recovery, or are there other forms of making good?
Well, in personal injury cases, damages are monetary. There's the only form that you can be compensated in. We can't take you back in time and make you whole again. So just to take an example, the easiest one, you're stopped at a red light and someone rear-ends you and you're pushed forward and back, or back and forward actually, because of whiplash injury. You actually get pushed back to where the impact occurred and then get pushed forward. So that neck snapping back and forth they call a whiplash injury, and as a result now you have to see doctors, you have medical bills, you maybe are out of work for a period of time, so you've lost wages, and your pain and suffering. So the person, to take you through all of those elements of negligence, owed a duty not to hit the back of your car. They breached that duty by driving negligently and hitting the back of your car. That caused you to be injured, and your damages are the pain and suffering, the wages, the medical bills that you're out of pocket. So when we have those cases and you get in front of a jury, you can't say to the jury, I want you to make my client's neck better again, because they can't. So what you do is you say, what is the value of the injury that they had, the suffering that they had to go through in order to go from the point they were after the accident until hopefully they've had a recovery.
So you explained that pretty well. Now, you understand that so many people take issue with the ethics or the lack thereof. At what point, how do you describe or define where ethics come into play here? Certainly, someone could have said, I just had a little hit, I really didn't have a whiplash, and you have to have some sense of ethics to determine whether or not this is a legitimate thing. What is ethics about from your perspective?
Okay. So there's a couple of different aspects of this, and so we'll break it down and make sure I answer what you're asking. There's the ethics of the lawyers involved in personal injury cases, and we can talk about that. And I'm not sure if you're also asking about fraudulent cases and people who just bring claims for the sake of bringing claims.
Because there's, yes, as you bring up, and yes, that's what I wanted to explore, it's, there's some sort of a burden of being truthful on both sides. But if you would like to address your side of it first.
You want to start with the lawyers?
Why not?
Okay.
Let's do that first and then talk about the
there are a number of different things that lawyers who practice in personal injury area should avoid and shouldn't do that can cross ethical lines. And that's something that I'm always on the lookout for, to make sure that my clients understand what the roles of the lawyers are and what we should do, and to make sure they're comfortable with how we go about it. In fact, in our retainer agreement, I spell out that I'm going to follow all the rules, statutes, and ethical obligations of a lawyer. So one of the things people do when they go to lawyers is they ask the lawyer to advance money. I want money before my case even starts. That's not ethical. Lawyers can't do that. Lawyers who do that are violating a lot of ethical canons. The rules of ethics state that you, for instance, a judge I knew used to call it champetry. You can't buy cases. You can't fund cases in the sense that you're giving money to clients. You can fund cases in the sense that you'll advance expenses. That's absolutely ethical. Your client needs to get the medical records so that they can be sent to the insurance company. Doctors or hospitals will charge for that. Lawyers can fund those expenses, but you can't give money to clients. So clients who come in and ask for money right out of the gate, I have to tell them that's not how we operate, and it's not ethical for any lawyer to operate in that manner. Another area where lawyers can cross the line is in trying to get cases in the first instance. It is unethical for a lawyer to solicit directly to a person that they don't know or have any relationship with to get a case. You can't do that. Now, we've had advertising for many years now, and at first there was an argument as to whether even advertising was ethical. Certainly, in my opinion, not necessarily professional if it's done in a haphazard or schlocky kind of method.
Sure.
But the rule is that lawyers have the absolute same rights under the First Amendment, free speech, to say what they want to say and get their word out. And it has been determined that that does not violate the canons of ethics that say you can't solicit cases, because you're not addressing it to one specific person, and you're not in a situation where you can overreach or give information or be in a position where they don't feel that they have a choice in what decision to make. It's advertising.
Defined as mass non-personal communications, so to your point.
Right. So that you can do. I argue that you really shouldn't be able to write letters to a specified target audience if you know that they have cases, even though if you don't have any relationship with them, to solicit cases. Other lawyers that I've heard of have people out there who try and go get cases for them and maybe even actually pay them money for doing that. That's absolutely unethical.
So beware anyone who's being approached
Right.
that way.
So if you're approached by someone who says, I know a lawyer, I can get you help, and you don't know this person, they've found you in the emergency room or some going through auto accident
Chase
reports.
the ambulance, David?
Sure. Those are not ethical ways of going about getting clients. So that's another area where lawyers can cross the ethics line. And there's many more, but the last one I think I'll address is somebody who I had to help out in a case where his lawyer took his funds at settlement and didn't pay the bills that were supposed to be paid, and didn't even turn the money over to the client for what their net of the proceeds should have been. Absolutely a very big ethical violation when you misappropriate and misuse clients' money.
Certainly unethical. And then from the injured party's side, some people are unethical, and of course none of our viewers,
Right.
But how do you define that in terms of the injured party is doing something that's not ethical?
Well, now this is another twofold discussion. On the one hand, there's a public perception
Yes.
that people are out there trying to hit the lottery, the personal injury lottery or jackpot. Most people aren't. Most people don't go out looking for injury claims. But there are some people who do. And, you know, they'll go to a restaurant and claim to have a slip and fall, or they'll create a situation where it's likely that they'll get into an accident. Those kind of people give the 99.99% of people who are injured legitimately a bad rap. The other bad rap comes from the insurance companies making it seem like there are more of those people out there trying to get money. And of course, the
Yes.
most famous one is the McDonald's coffee case, which
Yes.
was nothing like it was portrayed to be. This woman was seriously injured by a company that was selling coffee at a temperature that was well above the industry standard because they found they could sell more. They knew about the problem, they did nothing to resolve the problem, and they caused her great injury. And they forced her to go to court. They wouldn't settle with her, and they got what they deserved in that case.
And I think we do need to talk about who goes to court and who doesn't. But backing up just for a moment, you had mentioned that you outlined for potential clients what is covered, what you do. Should that be something that every prospective client should expect? A listing of what you do for what fee or no fee, or
Sure.
what needs to be reimbursed or advanced ahead of a case being settled or taken to court or whatever.
It's another rule of ethics, another one of the canons. Personal injury cases are taken by attorneys on a contingency basis.
All or some?
Almost all.
Okay.
If the lawyer believes in the case, then they'll take it on a contingency. If there are issues in the case, they may want some hybrid form of a retainer. But most personal injury cases are taken on a retainer, and which means that it's
on a retainer?
On a contingency
Yes.
retainer, which means that they don't get paid unless they get money. That's the contingency.
Yes.
And the rules of ethics require that contingency retainers be in writing. In other words, that there be a retainer agreement. So that's where I got thrown off a little bit, but I'm jumping ahead to the point that it has to be in writing. And so if you go to a lawyer on a case and it's in a contingency fashion, then if they're not going to violate the rules of ethics, they have to give you something in writing. And what should be in writing are the matter that they're handling for you. So this was an injury case that happened on a certain date. What's the date? That should be the start.
Mm-hmm.
What is the amount of the contingency? So for our firm, most cases are handled on a 1/3 contingency. So if we settle the case, our fee is 1/3 of what we settle the case for. And then in the next paragraph, we'll also state that there are some cases that if they go to trial, the contingency actually will go up to 40%. A lot of attorneys do that, especially in medical malpractice and product liability cases where there's an extraordinary amount of expenses that the firm is putting up in advance. Then the next paragraph will usually discuss the expenses. Who's going to be responsible for what expenses? In our contingency, we say that, our contingency retainer agreement, that we're going to put up any expenses for the client, but we'll collect those back at the end out of any settlement. If we don't have a settlement, we're not expecting the client to pay us back.
Good to know, because someone might be, as you say, unable to work, unable to have funds, then therefore unable to pay whatever some specific expenses tied to the case might be. So something for someone to know.
Right. And so I'm not done with that
Finish.
retainer agreement.
Finish.
So then we do spell out what the client can expect. This is what we're going to do. We're going to gather up all the information. We're going to put everything in a posture for settlement, and then we'll get to the point where the case is settled. And then in the next paragraph, we lay out for the client that when the case is settled, there are certain things that need to get paid out of a settlement. If there are any liens from doctors, hospitals, medical insurance, whatever, we make sure those liens get paid. We make sure that if there are other liens from a prior attorney perhaps, or whatever the case may be, that those liens get paid. And so the next paragraph says that this case will not be settled without the consent of the client. So when we come to that point, we say to the client, this is what the offer is, this is what all the fees, expenses, costs, and things that need to be paid would be, this is what you net. And we'll discuss whether or not it's fair and reasonable, and then together we'll decide whether it has to go into suit or if it can be settled.
So that said, I think it would be, that certainly is an awful lot of information for someone to digest. If someone is thinking about going to a lawyer, let's walk through what it is, how you handle a case. Apparently, for you to get to a place where you are estimating what the whole payout is, you must have done a bit of homework to know that, and that's a lot of work at times, perhaps.
I don't want you to be confused. The process is discussed. There are no numbers discussed at the time that you come into the attorney's office.
Good point, then. So when someone walks in to see you and you are thinking about taking a case, what is the process? Lay it out for us so that someone knows what to expect.
Most cases, the client comes in to explain what happened. So if it was an accident, they'll have a police report, hopefully. They'll bring that in. They'll explain what happened at the scene of the accident, how the accident happened, what they did for medical treatment, what their medical condition is now, whether or not they had a prior accident. I'd like to know. That is trying to get a little bit at that first thing. Are these people who are just out making claims, which you very rarely see, or is this a legitimate accident? And I also want to know, because there was a prior accident, what injuries did you have in that accident, and what was the state of the treatment for that accident? Had you already been released? Had you been released for some time? Because that can impact the value of your case. Then what is your medical treatment for this case? What is your wage situation? What other factors, what other things can't you do in your life because of this accident that you would normally do?
Okay, so when you're doing that, even in an intake session, perhaps, do you expect someone to walk into your office with as much documentation as they possibly can gather before they even decide to enter into an agreement with you, or is that something, that documentation gathering process, does that happen later?
We always ask the client to bring as much information as they have to the first interview, if they have it.
Good to know. Okay.
If not, it's not a worry, no worries, we'll get it. And we can get police reports, we can get all the medical documentation. That's what we do.
Yes, okay.
But what I want to be able to do is be able to assess the case for the client, tell them what we're going to do, and explain the process and what they can expect at that first interview.
And then at the end of that, they either sign with you or don't. If they don't, we know they might go next. Do you ever suggest to someone, maybe you might want to speak with someone else? Or someone might say, maybe that potential client needs to go to one or two lawyers just to get an idea, especially if they've not been through this ground before,
Right.
Hopefully not. Good idea, not good
Well,
idea?
absolutely. What I do is I want to assess the case from my firm's perspective. Is it a case that we want?
And how do you determine that, David?
Well, it depends on a lot of factors, but those factors that I explained at the beginning that go into it: is there negligence, is there liability on somebody, are there damages, and are they damages that can be collected? Is there insurance, or is there somebody that will be responsible and can pay for the damages? So if we have a case where there's no insurance and there's no likelihood of recovery, even though there are damages, my recommendation to the client would be it might be some case that we're not interested, but there are other attorneys that would. So I often refer clients who come in that have cases that we don't take to other attorneys.
So it might not be considered a strong case for you to take, but it might be a case sufficient that others might
Right.
take.
And they may have a case, for instance, a medical malpractice case, where I know a certain attorney has some expertise in the area of negligence that happened there, that I might say, well, let me introduce you to another attorney who does more of that type of work.
Would you really do that?
That's absolutely. Here's how I like to treat
Finder's
clients.
fee, David?
No, what I like to do with clients is make sure that they get the best representation that they can get. Most times I can provide that representation. There are some things that I know there are other attorneys out there that can do something better, have more of a stable of expert witnesses than I have for that area, and then I'll refer them to those people.
Okay. And do you want to continue the rest of the process of going through what a case is like prior to getting to either a settlement or a trial?
So what I explain to clients when they come in is, and oftentimes, not oftentimes, sometimes, they want to know how much the case is worth and when they're going to get the money. And an attorney at the initial stage, if you're still treating, can't tell you that, because the case is valued on what the pain and suffering is and how you recover. So you can't predict at the beginning of a case how somebody's going to recover. You may have back pain now, you may be going to physical therapy, you may get better. Or you may have back pain now, going through physical therapy, don't get better, and you need surgery. Those two cases have very different values and possibly very different outcomes. So what I explain is that we will work with you through the process, make sure you're getting the appropriate medical treatment, make sure that your case is being set up for the possibility of a settlement before having to be put in suit. But the long and short is, I can't sit with you at your first intake and say, oh, this is how much your case is going to settle for and this is when it's going to settle, if you are still treating, because you cannot legitimately settle a case until you know what the person's medical situation is going to be until they reach medical maximum improvement. They plateaued, they've been discharged, they're better, they're not going to get better, but we know what their scenario is. We need to know that before we can settle.
So a question that many people will ask, whether it was about an automobile accident or some other potential personal injury case, when do you know to go to a lawyer? Should you go right away? In some ways, what you're saying, if they want an answer about what's this worth, is this likely to be a case worthy to be tried or settled, you might want them, would you want them to wait
Immediately.
for, and
have
why?
to come in immediately.
Before they see the insurance company?
Absolutely, because what will happen is many times if you're not represented, the insurance representative, the adjuster will call you. They'll want to come and take a statement. You'll say something that you think is innocuous and really has nothing to do with the case, but the insurance company will turn it around on you. It's now on a recorded statement, and you have really maybe put your case at jeopardy without even knowing it. And it really probably something that may not even have been relevant. So if you want your case to be handled appropriately, make sure you're okay, see the doctor first. You may not be okay, but get medical treatment first, but then call an attorney if you know one, or have somebody that can refer you to one. Get to an attorney right away and start finding out what your rights are and how you can protect them.
Are you going to suggest that they not speak to an insurance company at all?
Correct. Not without an attorney there.
Not without an attorney there. Good to know. And cases may take a short period of time, long period of time. What goes on during that process? What are some of the work behind the scenes that we don't generally see or hear?
Well,
explain if you would.
Let's take, you said there are different types of cases. There are different types of cases. Let's take a slip and fall, for example. We handled a slip and fall for a person who was severely injured, and it happened in a theater where the lighting had changed, and there was a curtain along the side, what she thought was the side wall, that was not a wall at all, but just a curtain. So when she put her hand on it to protect herself, she went right over it and down.
Oh my.
And so what we did was immediately contact the insurance company, the theater, and made arrangements to get out there to see it before it changed. So we took an expert witness in architecture to determine whether or not they violated building codes and that type of thing. We took a photographer, a videographer, to film the situation the way it was on the day that she fell, so that that could be preserved, because they change, you know, when they change plays.
Be specific, David. How much time had actually passed between the time this person had the incident, called you, and you had this take place? Is it a day? Is it a week?
Within a week, maybe two.
In that case, it's a reasonable time frame to expect that they hadn't altered the situation. Okay,
right,
good to know.
Because the same play was still playing.
Good to know.
So that nothing had changed. Another example, I had a client who was injured in a products liability case. She had a bottle disintegrate in her hand in a supermarket and cut her leg, actually cut a nerve in her leg, and did some serious damage. So in that case, it had come to me, but what the attorney had done initially was immediately find an expert to go to the supermarket who had locked the bottle up in a office, and went and got the pieces and put it back together so we could determine why the bottle fell apart, what the defect was in that case. That was within days.
So that ends up being a case for that injured party, but then also does it end up being a suit against the company or the manufacturer who had a product defect?
In a products liability case, the person who sells the product is liable, the person or distributor that they bought it from is liable, and in this case, the manufacturer of the bottle was liable. So it goes in the stream of commerce, as they say, and everyone in that stream has liability. In this particular case, the manufacturer of the bottle was known, and therefore they were the ones who took responsibility after the jury told them they had to. Because I had to try that case.
And then with product liability, we read so many cases, I guess Fosamax was one, where someone might have been taking it for quite some time, but they didn't know that something was wrong right then and there. So the timeliness issue, you can't take it today and then go call a lawyer tomorrow, because there might not be some sort of an impact, or maybe it has a cumulative effect. But by the time there's a suit somewhere that indicates someone has now some problem, a necrosis of the jaw, or whatever I think was the case. But now, if there's a class action suit, because it's a very big deal, can someone locally still come to you and say, can you help me because I have some side effects, and this was years ago that I took that medication? Can you help someone in that case?
Yes, there's different rules on discovery of injuries and that type of thing. But the long and short is most, not all, but most class action suits are class action suits because they're too expensive to bring on an individual basis. Not to say that they can't, and where the damages are catastrophic, sometimes it's worth doing.
Good to know. I understand in the short amount of time that we have, there's an issue about different state to state have different rules about personal injury, and I understand in Rhode Island, I don't know if it's just about car accidents, but there's a statute of limitation. You talk about going to see a lawyer ASAP. Is there one rule of thumb about just car accidents in the state? How do you determine?
Personal injury. Generally speaking, personal injury cases have to be filed within 3 years from the time of the injury.
Okay.
Now, there are some exceptions to that, and you need to consult an attorney to find out if that exception specifically applies to you. In the medical malpractice field, for example, there may be some rules that allow a different date than the date of, let's say, it was malpractice for surgery, but they're very complicated rules. So you need to speak to an attorney as soon as possible. But generally speaking, 3 years.
And speaking about car accidents again, if there's an example where you know for sure that the person who hit you, he's taking responsibility, yes, it was my fault, mea culpa, is there any reason to get you involved?
Yes, absolutely.
Because?
Because, I'll give you an example. I had a client who was being offered $10,000 for their injury. They came to see me, is this a fair offer? Do I need you? Let me look at it. So we went through it, and the scarring itself was probably worth $100,000 in that case, and we ended up settling the case for $3 million. So there are times where insurance companies almost always will want you not to go to a lawyer because they'll make you an offer and they'll tell you they're taking responsibility, but their responsibility and the fair value of the case are often two different things.
And I guess to your point there, while there might be someone who's fraudulent and wants to bilk the system out of personal injury, here's an occasion that you're saying perhaps that injured driver wouldn't even know what the real cost,
what the value of the case
and the value is going to
right.
be. How long is there a specific amount of time that you can reasonably project where you would be able to assess what the dollar payout value would be for someone who takes any kind of personal injury case to you, whether it's product liability or
I'm not
otherwise?
following what you're asking.
So if someone comes in, meets with you once, twice, it's a month, it's 3 months, is there a range or a reasonable amount of time where you might be able to come to a conclusion where you can say, I think we should be able to eke out XYZ dollars and cents? Is there a time period that people should be aware of, or just let it play out as it does?
Every case is different,
okay.
And every case is dependent upon the person's injury and how long it takes them to recover and what their medical condition is.
Again, quickly, if you can address this, comparative negligence, who's got the deepest pockets?
Right.
Give us
you need more than a minute to really go into all of that. Rhode Island has comparative negligence, which says that if the plaintiff contributed to his injury in some form or fashion, that is going to get deducted out. In Massachusetts, it's contributory negligence, which says if the plaintiff is 51% or more at fault for the accident, he's going to get 0.
Good to know. You did handle that fairly quickly, even though I'm sure you could elaborate.
There's a whole lot more.
We might need to address that again. We thank you for tuning in. Our discussion of legal matters will continue. Stay tuned.